Good day to you and welcome to another Paddocks Club video tutorial. Recently, in Paddocks Press, we ran an article by Craig Lardner suggesting that more transparency and detail is required in managing agency contracts for the benefit of both sides and for that of the industry generally. That thought leads me on to some important items that should be specifically dealt with in managing agency agreements or in other written agreements between a scheme and its managing agent. This week I will deal with the first 5 of 10 issues, and those are financial records and scheme funds, body corporate books of accounts and records, property inspections and reports, effecting repairs and maintenance, and paying disbursements and expenses. Firstly, the issue of undertaking the financial management of funds and books of account. This is an absolute usual and arguably the managing agent's most important task. But does the managing agent actually have a free hand to do things, to move money between accounts, to invest, and all that sort of thing? No, that's not unusual. Or must these decisions be approved by the trustees in advance? The managing agent should, I submit, be obliged to disclose any commissions or interest received on these accounts, but also any more indirect financial benefits. Most major managing agency frauds are preceded by the managing agent moving money from a reserve account to an operating account, where it is mixed often with the funds of other schemes. But that's another issue. You probably know my strong views that every scheme should have its own separate bank and savings account. But think about this when you enter into or renew your managing agency contract. It's best to have specified and detailed provisions in the contract that deal with these important issues and let both sides know the limits of the authority given to the agent. Let's move on to holding documents and scheme records and maintaining these for the scheme. And I'm thinking of financial records, lists of owners, notices, and minutes of meetings. And of course, the managing agent will normally arrange for inspections of these documents by owners and others entitled to access to them. It's a usual feature of a managing agent's job. But where will the records be available? During what hours? And what will the managing agent charge? Will that charge the managing agent levies be credited to the body corporate or to the managing agent as a fee? Some managing agents charge for their time during which they make those documents available at the same rates as accountants and lawyers charge, so it gets very expensive for the owners. The ownership and handover of the administration records is something else that should be agreed in writing, and more particularly it should be clear that all the records belong to the body corporate and that the managing agent must hand them over. It cannot hold on to them as security if there's a dispute about unpaid fees, because this would allow the managing agent to effectively hold the body corporate to ransom if they fall out in this regard. Next, I want to talk about arranging property inspections and reports. Again, it's a very usual thing. Who can initiate an inspection when it seems to be necessary? Must the trustees approve this, or can the managing agent just do it? Up to what limit can he spend money in this regard? Again, things that should be agreed in advance. Let's move on to effecting repairs to and maintaining common property or engaging appropriate qualified tradespersons to do that. Are there limitations on expenditure that the managing agent may incur without obtaining the trustees' approval? Again, a usual feature of a managing agency agreement that really should be thought about in advance. In regard to both investigations and the subsequent repair and maintenance work, must it be put out to tender to ensure a good price, unless it's urgent? And if it is urgent, who will be used? Is there a list of preferred suppliers? Make sure the managing agent is obliged to use someone who's entirely independent, of course, because managing agents do often have interests in service companies, and even when they don't, kickbacks from service providers are a bane of the managing agency industry, and in the end, the scheme pays an inflated price every time. Finally, I'd like to talk about paying disbursements and expenses incurred in connection with the managing agent's management of the scheme. Do these have to be signed off by a particular trustee or at trustees' meetings? Obviously, you can't keep the managing agent's disbursements back. It's money, it's his cash flow. You must give him his money as soon as possible. Who must sign off? Who checks the detail of this? Next week, I'll continue with dealing with another 5 issues. Thank you for joining me, and if you have any comments or queries, please post them in the discussion forum.